Welcome back to another edition of Between Two FARS. I'm Warneke Miller, and I'm here today with the illustrious Robert Tepfer, the Bob, as he's commonly known in the circles of procurement attorneys who are just adoring his vast knowledge. And today, he is going to give us...
Tired.
I love introducing you, Bob. Actually, this is a very important episode because when you're talking about long-term litigation like the ASBCA, you need to begin with the end in mind. So we've talked about all the preliminary issues that you encounter when you find out that you've got litigation filed. But now this is where the rubber hits the road. You've got to prepare your case. You've got to have a global understanding of what's going on. So today we're going to talk about the actual functional steps that you need to take to prepare your case. So Bob, what does it mean when we say begin with the end in mind?
Well, I mean, it reminds me of writing a book. And if you've ever talked to anybody who has, sometimes you say, how did you think that would work out? And they roll their eyes and say, of course I knew how it worked out. And that's where you are as a trial attorney. You know what the elements are that you have to prove. You know what the findings of facts are with regard to your specific case. And you know ultimately you're going to write a brief. Okay? So one of the tricks of the trade is, to the extent you can, you write the brief before you go into discovery with certain witnesses, if you have insight, and certainly before you do the hearing, because there's nothing worse than getting it to the end and saying, my goodness, I wish I had asked these witnesses about those documents. Okay?
Now, for somebody who's not done ASBCA litigation before, it's important to note that after you have your hearing, the judge will normally ask for a post-hearing brief. They are expecting the attorney to write up all of the facts, all of the law, and how the evidence that came forth during discovery and during witness testimony during the hearing, evidence that your side should win this case. Now, what Bob's actually advocating is before you even get into deposing the other party's witnesses, are you telling them maybe you need to start thinking about or even drafting that brief that you wouldn't have due until after the hearing's over?
I guess to the extent that you want information from witnesses from the other side, yes, you absolutely should be doing that. You should know what your witnesses are going to say. You need to confirm that's what they will say. And you need to make certain that you put it in the record at the various points in time, along with the critical documents. Now, you know, that's going to evolve as we go on. And Warneke and I discussed this before we recorded this. And the reality is you write a lot of briefs if you do it right, and do a lot of findings of facts on cases that don't go anywhere. Because when you get that information, if you're dealing with opposing counsel that's really skilled in this area, they can see the writing on the wall. And they'll either agree to settle or agree to go away based upon what they can tell that you've obtained. And so it's not just a method for purposes of trying to win your case. In most of these instances, when it looks like you're going to win the case, they cut their losses. They either come in with a different settlement offer or they go away. So you do a lot of this, what appears to be nothing, but it implicitly, it's kind of your checklist of the elements that you have to have, and the other side is writing down what you've got.
Yes.
And what you don't want to do is you don't want to overlook something and then wish you had testimony to that fact or had them, you know, speak to a particular document. Okay. Yes. Now, I've had instances where, you know, I say that the case goes away. Sometimes you put this all together and you realize there's one element missing. And you go through all the documents, you go through all the witnesses, yours and theirs, and you realize there is no way you can establish that. Well, the sooner you ascertain that, the better you are, because it's going to be a point that you're going to, maybe on my case, I went to the chief counsel and say, this event, I can't prove ever took place. And these documents, I can't find that they exist. The opposition doesn't seem to know that I have a losing case because of that one aspect. Better I should start negotiating now than wait and put it into evidence or not have it in evidence and have the judge rule against me. So it becomes a way you're negotiating not only with the other side, but with the powers that be as to what's wrong with your case. Because as we've talked about before, they are always convinced that they're right. They're always convinced that you don't do anything except stand up and take credit for it. So when you show those elements to them and you show them the brief that you can't write and what's missing, a lot of times they will back off and pull out their billfold and get ready to pay.
Yes, if you begin with the end in mind, any of your diligent efforts will be useful, because that brief, you may start writing it thinking you're going to use it to convince the judge that your case is a winner, but it may end up being the paragraph that's needed to substantiate why you're paying out, why you're using taxpayer money to reach a settlement. I've never found any of those sort of early work efforts to be useless. That drafting that you do always evolves into something you need to paper the file, whether it's helping your contracting officer substantiate why they're modifying the contract or why they're paying a request for equitable adjustment, or you're using it internally to convince the management chain that this is a litigation risk that they need to take seriously. Now, ideally, you would be using this as your brief at the end, your post-hearing brief, because we are righteous, we are just, and we've not discovered anything that makes us realize, whoops, we need to pay out on this one. But it doesn't always work that way. I don't know about you, Bob, but I tend to suffer from overconfidence. And what I find actually sitting down and writing out the brief, structuring out what the case law is, a lot of times I go in thinking I know what I'm talking about, thinking I know the state of the law, thinking I know what facts we've got. But until I sit down and commit it to paper and figure out which documents support which elements of the law, does this really help me shoulder my burden of proof? I may be thinking I've got a stronger case than I actually have. And so sometimes it's kind of a wake-up call for me as well to adjust my perspective on how solid our case is. And like you said, doing that earlier rather than later will save the government money if we have to settle, because you want to realize your flaws, not have opposing counsel point them out to you.
Yeah, lawyers are legendary for falling in love with their cases. And, love is blind, but opposing counsel will be kind enough to point out those aspects to you. And that's no fun at all. So I think writing it out is really a good thing. And along those same lines, when you write it out, you may not realize it because you may still be in love with your arguments, but you may be writing the basis for a settlement statement. Yeah. And those need to be as well written as well, because the IG or the auditors, GAO, they're going to be doing their job, and you have to make a convincing statement that there's an issue of entitlement. When you write that out in your final brief and the holes are there and you can't figure out how to fill them in, you really take that and you put that down in your settlement agreement, and you simply tell the story. The same story that you might orally go in and tell your boss that this case is not going to be a winner and why. Yeah,
that initial document you start drafting is going to be by you, written and rewritten and rewritten. I mean, the art of writing is rewriting, and it's going to evolve and change into maybe a different document than the one you expected to be writing. So it's very important that you always have a draft watermark on it, and somewhere in the header or the footer where you say attorney-client privilege or attorney work product or both, because you want to make sure that it is clear to whatever auditor or IG investigator picks this up off of somebody's hard drive or off of an email that you sent to a client, that this is not a final document. This is your thought process, and it's you working through this case to be able to give the best advice to your client, to the government, as possible. And as long as you're protecting your early work with those watermarks and those caveats, the attorney-client privilege work product type of headers and footers, feel free to just spill your guts onto the paper and really work it out, you know, work through your mindset and find out what this case is all about. All right. I did a lot more of the talking during this episode than I thought I would.
Well, you've got a lot of experience in this area, and I think it's important to note, not only with those drafts, and we could have a separate discussion at some point just on emails, because the nature of what we do now is such that you want to talk about attorney-client privilege and work product and protecting it. Oh my goodness, you can't, you know, it's just not easy to make a phone call to discuss some things, and you have to email something, although I don't like to. And that all needs to be protected, and folks need to be educated at the inception that, you know, you're sending it to them, it goes no further, and protect it accordingly.
Well, and I think we've learned how to do that with email. We can go ahead and put those same caveats in the emails. But if you really want to scare your clients, think about all the new technologies just with the teleworking that's happened in this last year. We're filming here on Teams. So many times meetings are filmed. Chats take place in the sidebars on some of these phone conversations that aren't recorded. And that stuff, you know, in time we'll find out how they're going to play in discovery. But are we always saying, hey, this is an attorney-client communication, this is privileged communication? We need to be aware of that sort of stuff and protect our thought process during the litigation process to make sure that there's an understanding that this is attorney-client communication, this is internal and attorney work product, sorting through the facts and the case law and trying to come up with our theory of the case. And that stuff will be protected by the courts, but we have to make sure that we're marking it as such during this whole process.
Yeah, that, you know, to me, it's an evolving process because of the technology.
Yes.
You know, I did cases 25 years ago, and issue of metadata was not an issue. And when it became an issue, there was an element of vulnerability. And I'm not, you know, I'm not certain what they've got at what stage they have it. And you as an attorney, and I think some state bars require you to have a certain element of sophistication with regard to the technology, and you simply can't stand back ethically and say, well, I'm not, you know, an IT person. And the answer is, well, you might have to be a little bit to some extent, to the extent that it impacts the integrity, attorney-client, or work product in what you're handing out. So this morphing of the brief and how it can evolve and who it goes to, and ultimately what it ends up, whether or not be a settlement statement or the actual brief, is something that needs to be protected, not only with the proper statements, but with regard to who gets it, and also any kind of metadata and the like.
Yep, that's starting with the end in mind is twofold: figuring out the theory of your case and protecting the theory of your case. Join us again next time. 2 FARS.